can take the form of different types of action, the legal importance of which varies greatly depending on the type of action, and it is possible that a single act may constitute several offenses at once. Cyberbullying, therefore, can constitute a crime. It can be a menace. It is regulated by Articles 169-171 of the Penal Code 16, according to which the perpetration of this crime requires the occurrence of the following elements: the existence of a menace, the fact that the menace causes damage regardless of whether there is a crime, the existence of conditions not to cause such evil. In most cases, the menaces are physical harassment of the victim, usually in schools, and the child is unprotected against repeated attacks by the harasser. The harm with which the victim is threatened may or may not be a crime, but it should be noted that the threat most frequently used on the internet is directly related to the honor and privacy of the victim, with cases where the harasser intimidates his or her victim by posting images or videos that could put him or her in a compromising position in relation to third persons. The affected child often hides the situation despite the existence of specific legal protection and regulation for fear of reprisals that might result. Coercion. This type of crime is regulated by Articles 172 and 173 of the Criminal Code, which establish that this crime occurs when the following elements take place. A third party is forced to do or not do something. The fact that dignity, fame, or self-esteem can be damaged. It is possible, therefore, that the crime of coercion may occur during harassment, provided that there is violence. In this case, the element of violence must be understood in a broad sense, including both physical and psychological violence, and applied to people or things. Calumny. This crime is regulated by Articles 172 and 173 of the Criminal Code, which establish that persecution of this crime requires the occurrence of the following elements: the existence of an action or declaration, and the fact that dignity, fame, or self-esteem can be damaged. The offense of calumny normally consists of a declaration involving the attribution of untrue facts, making value judgments either verbally or in writing, or in a symbolic manner by caricatures, emblems, etc., which are not true. This action, however, can also be understood as an act of omission that implies both negligence and an action that damages the dignity, reputation, or self-esteem of the person. In view of the importance that this type of behavior has in the online world, situations and behaviors that previously existed in the physical world and cause significant damage to those involved must be taken into consideration. In any case, with the introduction of the electronic element and the greater extent of the damage caused to the users concerned, the damage is much more serious than it could be in the physical world. Defamation. It is regulated by Article 205 of the Criminal Code, which provides for the occurrence of the following elements in order for this type of crime to be recognized: that there is an accusation of a crime, that this accusation is false, that the attribution of the crime is based on a specific fact, that the imputation is made in respect of an identified or identifiable person. Although less frequent among online harassment, it is perfectly possible that false crime charges that have not been committed are associated with insults. The crimes expressed above constitute the full range of acts that can result from cyberbullying. Attention is more commonly focused on early behaviors. In addition to the recognition of these offenses, compensation for damages which the interested party may claim in civil proceedings or as liability arising from the offense may also be included. Of particular relevance is the fact that the publication of this type of content of defamation, slander, threats, and coercion is found on public websites and can be freely indexed by search engines. This means that the accessibility and viewing of this content increases exponentially, thus aggravating the damage to users' rights. Now let's talk about the criminal liability of the child for cyberbullying. From a legal point of view, the main implication to be considered when acts are carried out by children is the criminal liability of the child. In this sense, it is a priority to discern when a child is considered a non-attributable subject, not responsible for his actions because he does not have the necessary degree of maturity, or when he is considered sufficiently mature to be judged. In this respect, the following laws are applied in criminal regulations based on the age of the offender. The Organic Law 10/1995 of 23rd of November 1995 approving the Criminal Code. This law applies to persons of legal age and, exceptionally, to minors between the ages of 16 and 18. The Organic Law number 5/2000 of 12th of January 2000 on the criminal liability of children. This law states in Article 1 that it applies to persons between the ages of 14 and 18 who are considered responsible for the offenses they committed under the Penal Code or special criminal laws. This law, therefore, reduces the age at which a person can be held liable and criminally liable. The two regulations also provide that the provisions of the law governing the criminal liability of minors in the cases and for the persons covered by the requirements set out therein may be applied to persons who commit a criminal act and are over the age of 18 and under the age of 21. The law adds that this can be done when judges consider it necessary that those who are defined by criminal doctrine as young adults may be subject to the law of minors. As stated in the law explanatory memorandum, the response of the Penal Code for children must be twofold. Penalty, which means that a judicial measure against the violation of a criminal law which encourages the acquisition of responsibility in the child subject to rights and obligations, and the educational character where the child's best interest and the special prevention of his or her education are more important than the special remuneration and prevention that is characteristic for adult criminal law. Therefore, on the basis of this principle, certain behaviors cannot be punished even though they are recognized in the Penal Code, because they are considered counterproductive for minors or because they are carried out by persons under 14 years of age, and these persons are considered not to be indictable for the purposes of criminal responsibility.